Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. Welcome to the new subscribers and welcome back to our devoted listeners. If you're here, you know that I've covered the Darlie Routier Trial transcripts from the very beginning. The mother who, in 1997, was accused and convicted of murdering her two children in Rowlett, Texas. If you're brand new here and want to start from the very beginning, you'll find all of the trial transcripts in their own playlist on YouTube. The actual trial testimony is over, and we're now into closing statements. In this episode, we continue with the final closing statement from the prosecution, and then the jury deliberates, and then we hear the verdict, all in this one episode. So let's start with the statement from Mr. Davis of the prosecution. The court then says, "Thank you, Mr. Mosty. Mr. Davis, you have 45 minutes. Mr. Davis says, "Thank you, Judge." And remember, he's part of the prosecution. "May it please the court?" The court says, "Yes, sir." And Mr. Davis continues. "Ladies and gentlemen, before I begin, and I have 45 minutes, but you will be relieved to know that I am going to be the last lawyer talking to you today, and that probably does come as a relief. But I want to also thank you, not for serving, because really you didn't have a choice about that, but I do want to thank you for the very close attention that you have shown throughout this 4 weeks. In my 19 years, I don't recall a more attentive jury. And there were times, as we talked about in the opening statement, where unfortunately, you had to see things that really no juror should have to look at. And you had to hear things that no juror should have to hear. But I appreciate the attentiveness to the facts because it's on the facts that the truth is shown in this case. Not on lawyers' statements, lawyer talk here this morning, but it's on the facts that you have heard here over the last 4 weeks. That is what really counts in this case. Now, you have just heard 3 very fine attorneys among the 5 that are over here at this table. They are very fine attorneys, all. And you have heard now 4 very fine arguments from those 3 attorneys. I hope that there wasn't a one of you sitting over there in the jury box that was surprised to find out that none of these attorneys over here are satisfied with the state's case. In 19 years, I have never seen it happen. And I dare say if I live to be 100, and if I am still out here practicing law, I don't think I will ever see it either. It just doesn't happen. If it did, we wouldn't be here today, would we? You know, Mr. Mulder would have you believe that there was some sort of conspiracy on the part of the state of Texas here, in this case, to mislead you good people. Here is my answer to that. If there is a one of you, when you go back there to that jury room today, if there is even one of you who believes that, before you look at any of the evidence in this case, any of the facts before you, if you believe that, you write not guilty and you come back in here. That is how strongly I feel about that. There has been no effort at all to mislead you good people. There has been an overall effort here over this 4-week period here from this side of the table anyway, to try and show you the truth as best we know how. And we have done that. You know, if I was going to mislead the people at this table over here as they claim, would I, over 3 months ago, have given them material that might in some way help their client? Would I have done that? You know the answer is no. I would not have done that. I would have swept that under the rug, under the carpet, and said, we don't need that stuff. But that is not the way we operate. We hand it over, good or bad, and let them use it as they see fit. And that is what they have done in this case. I'm not going to apologize for standing up here and representing the good people of the state of Texas and Dallas County. I'm not ashamed to be sitting at this table. I'm not ashamed at all of the good people from the Rowlett Police Department who are still down here in this courtroom today. You know, these are the men and women who protect us. These are the men and women who, when they got that call on June the 6th of 96, they are the ones that we sent over there to 5801 Eagle Drive, aren't they? And they had to walk into literally hell that morning at 2:35 in the morning and start dealing with that hell and start dealing with this woman right over here, Darlie Routier. They didn't ask to do that. You see, that is their job. And that is what they did in this case. And they have got absolutely nothing to be ashamed of. And I am proud that they are part of our case. And I am proud that they are sitting in here where you can see them this morning. There is one other thing I am very proud to do. I am very, very proud, most of all, in this case, to be the voices for Damon and Devin Routier. You know, the two little boys, we almost forget them. You know, the pictures were put over here, I suppose, after Mr. Shook's argument. I don't think it takes a genius to figure that out. You know, these two little boys right here, they don't have voices anymore, do they? They are dependent on us, Mr. Shook, Miss Wallace, and myself, and I will guarantee you I am going to use my voice this morning to the best of my ability to talk for these two little boys who never had a chance as their mother slaughtered them there on June the 6th, 1996. May we never forget these two precious children. May they always be a part of this case. You know, this case, I think, shows a very distinct difference in good and bad. It shows you a very distinct difference in what the guilty do and what the innocent do. It's been a textbook almost on what does a guilty woman do when she comes to trial in Kerr County. The first thing she does is she tries to deceive you. Mr. Mulder used that word, misleading, misleading, misleading. If there is anybody in this courtroom who has tried to mislead you throughout these past 4 weeks, it's this woman over here. Just like her husband, trying to materially alter her appearance for you. She doesn't want you to know who she really is. That is why she sits over there, like she is today, with this plaintive little look on her face. Poor me, I am the victim kind of look. Hoping that just one of you, because it only takes one of you will buy into that game. And then what do you do beyond that? Well, they blame the phantom intruder. Mr. Mosty made mention of Charles Manson out in California. I think what we saw by this team over here was what I am going to call the Susan Smith defense. That phantom intruder. You know that fellow. Remember, it was a black man in South Carolina, supposedly, that took those two children. It's that man that we just don't know where he went to. We can't describe him. My goodness, I don't know. It's the phantom. And you stay with that phantom until all of the evidence in this case shows that is totally impossible and inconsistent with what they found out there on Eagle Drive that day. And I don't have to go over that. Mr. Shook did a fine job of doing that this morning earlier. But you stay with that until that one doesn't work. Then what do? You go to Glenn Mize and you point the finger through those letters at poor Glenn Mize and you say, I know it's Glenn Mize. Not that the investigators have told me that maybe it was Glenn Mize. I know it's Glenn Mize. And you stick with that until poor Glenn Mize has to trot into this courtroom and stand before this accuser, and where she finally has to admit it can't possibly be Glenn Mize. Then what do? You go to a man named Gary Austin. And you say, I guess maybe it's this Gary Austin. You know, this guy that lives all the way down the block who can magically, I guess, look over the horizon into her backyard and watch her while she is in this hot tub. If that one doesn't work, then you go to Angelia Rickles and you say, well, it must have been those two guys over there on Miami Drive that morning. But there's a couple of problems with that. Angelia Rickles, you had a chance to see her. Did you really believe that she can accurately recall what happened to her that night? I mean, a man is supposedly bumping on that doorknob for 10 minutes solid. And this woman says she is alone, her husband is not there, and she doesn't call the police. Maybe that happened, and maybe it didn't. But what you do know is this, that the description of the two men that she saw there at her house don't in any way match the description that this woman over here gave to the Rowlett Police Department, does it? Cowboy hat, cowboy shirt, long sleeved for one of them. That is not the man that she described out there on June 6th or any other date. Another man is wearing a toboggan with a dark jogging suit, long sleeves. That is not the description either, is it? So even if those men were there for whatever reason they were there, we can rest assured that they are not the man that came into her home that morning on June the 6th. And as a last resort then, what do? You go for this man in the dark t-shirt and dark cap that was talked to, not on the morning of June the 6th, but the afternoon of June the 6th, some 14 hours after this thing happened. And you see, it's kind of like that Paul Harvey show. You didn't hear the rest of the story. Mr. Mulder knows his name as I do. His name is Wilford Davis. And Mr. Mulder told you something that wasn't true. Maybe inadvertently he did that, but he said to you, we didn't get his fingerprints and match them to the ones on that window out there at Eagle Drive. And I'll stand before you right now and I will tell you that the state of Texas did. When we called, Mr. Mosty then says, that is outside the record, Your Honor. Mr. Mulder says, again of the defense, Judge, if they did, they haven't told us. Mr. Davis says that is not exculpatory evidence. The court says, just a minute, gentlemen. The jury is instructed to remember the testimony as they heard it and be guided by the charge of the court, and both sides are reminded to stay within the record. Mr. Greg Davis says, yes, sir. As invited argument, I'm going to tell you that is not true. Mr. Mulder says, Judge. Mr. Mosty says, that is an absolute misstatement. There is no, and Mr. Mulder says, no one has ever told us. Mr. Mosty says, there is no evidence of that. And the court says, just a minute, gentlemen, one defense attorney at a time, please. Mr. Mosty says, that is not in the record anywhere, anyhow. And the court says both sides are ordered to stay within the record and the jury is ordered to remember the testimony as they heard it and be guided by the charge of the court. Please continue. Mr. Davis says, yes, sir. And then, I guess finally, it is some drug-crazed maniac. I think that was Mr. Mosty's term. You know, where is this drug-crazed maniac and where does that idea come from? If there is some drug-crazed maniac out there that is a suspect, then I want to know this. Where are those investigators that were hired by the defense to go out to that neighborhood? And don't you know that if they had found someone like that, there is no way in this world that they wouldn't have been sitting on that witness stand telling you people about the folks that they found out there? But that is not what happened, is it? All right, next one. When all of that doesn't work, what you do is this. You blame the police. I don't know of an older defense. It's the most regularly used defense, certainly. But you look at these police officers and you say they just didn't do the job right. They either didn't do enough or they did too much. You kind of take your pick on most of these cases. And you say to them, you know, you put her in the crosshairs immediately and you weren't careful enough. Ask yourselves this. If the Rowlett police had gone out there on June the 6th and decided, this is it, Darlie Routier is the one and only. We don't care about anybody else. We're not going to look for another suspect. This is our suspect right here, and we're going to make our case against her. You just wonder. I guess somebody forgot to tell Charles Hamilton about that morning, didn't they? I mean, here is poor old Charles Hamilton out there for 5 hours trying to lift fingerprints from that house. Now, why would they have done that? Gone to the trouble of trying to find the fingerprints of that intruder if they had already decided that this is our one and only suspect? And why would they wait for James Cron? Why not just go ahead and get in that house and go through there and say it all matches Darlie Routier? They didn't do that though, did they? They waited until a man with 39 years experience in crime scene search went out there and assisted them. Why would you call for Charlie Lynch and Catherine Long from Swift's if you already know who you want to charge over here? Why go to the trouble of finding the blood evidence? Why go to the trouble of having over 100 blood samples DNA tested like we did in this case? Why do you do all of those things if you have already made up your mind that this is our suspect? You don't do that. You do that because you want to know the truth, the most complete truth possible. And that is exactly what they did. And that is exactly what we did in this case right here. The next person that you blame must be the medical community. You say the nurses. You don't remember what you remember about what she told you out there that day. And when it comes to the bruising, you 6 skilled nurses and you doctors don't know what you were doing out there. You missed this obvious bruise out here. You were negligent in your duties towards this woman. You know, it's interesting. I watched Mr. Mulder while he showed where that bruise was in that Polaroid. Did you notice the arm? Did Mr. Mulder point here to the inside of the arm? No, he didn't, did he? He pointed on the outside. where that wound was, where you would expect to see a redness on June the 6th. Not over here on the inside of the arm where that bruise shows up on June the 10th of 1996, did he? And then, to buttress your case against the nursing profession out there, what do? You bring in family and friends who might as well have been sitting on the front row of this gallery throughout the case. They know as much about this case as you do as jurors. And after all of the evidence is in from the state, they all get up here with a very clear memory, apparently, with no photographs to back them up, because you see, it wasn't important back then. They all tell you, oh, sure, I know that bruise was there all the way from here up to here. Except for one. It was curious. Karen Neal. Of all of them that came in here, who was the registered nurse of the lot? It was Karen Neal. And what did Karen Neal tell you about that bruise? Do you remember? When Mr. Shook asked her about the location, she didn't point to the inside of the arm where the family and friends had pointed to. I was watching her very closely, as I hope you were also. She went right to that outside, didn't she? Right to where you would expect the wound to be. Not to where the others said they saw that bruising. And she is the registered nurse, just like the others from Baylor Hospital, who know what they saw and know what they didn't see. There was no bruise at Baylor Hospital. Who do you blame next? You blame James Cron. What you do, you call him that old bearded man who came out there. You call him a fingerprint man. Even though you know he is a senior crime scene analyst. I mean, that is what the man does. And you say he just waltzed through that house and he came up with this conclusion like that. Folks, it wasn't rocket science that we were dealing with out there. A man with 39 years experience walked through that house and it just stuck out like a sore thumb. Her story doesn't match the evidence. And now you have had the opportunity to see what he did. And you can see why he walked through there and said, it doesn't match up. We need to look at some things. You people know what you are doing. Let's do the testing. Let's do the printing. Let's do all of this stuff. But I am telling you right now, from what I know and from what I see, it doesn't match up. And he was the starting point in this case. He was not the finishing touch. He was the starting point. And then what do? After they blame Cron, they come in here against Charlie Lynch and they say Charlie Lynch gave, I think the quote from Mr. Mosty was, he gave you a bunch of unfounded opinions. I think unfounded opinions are opinions that they don't like. I think that is the definition that we can conclude unfounded opinions are. What did Charlie Lynch tell you? He told you that he found that fiberglass rod and he found that rubbery material on that knife. Up to that time, he had never seen a compound before under the microscope, like the rubber compound that he found on that knife that just happened to come out of the butcher block out of whose kitchen? This woman's kitchen. Never seen that. What did he see when he looked at that window screen? What did he see right here? He saw the same two things. He saw fiberglass and he saw this rubbery material that he had never seen before. And there was one more thing that he saw there that the defense just didn't mention during the arguments. He saw embedded in that rubbery material fragments of glass, of fiberglass that were wed to the rubber material. And from that, he told you that he could conclude scientifically that the rubbery material and the fiberglass in it were placed on that knife blade at the same time. Now, we know that Charlie Lynch was right about one thing in this case. He was right about that sock, wasn't he? When he told you those fibers were consistent with that shoe, Darren Routier's shoe, was Charlie Lynch right or was Charlie Lynch wrong? We know he was right because Darin Routier, thanks to Corrine Wells, had to get up here and tell you. Mr. Hagler of the defense says, "Excuse me, Your Honor, I believe he's going into something that is not in evidence." And the court says, "The jury is instructed to remember the testimony and evidence you have heard, and both sides are instructed to remain within the record." Mr. Davis says, "Yes, sir." Mr. Hagler says, "Could we have a ruling on that, Your Honor?" The court says, "Well, I'll overrule that." Mr. Hagler says, "He is going to go into a matter that is not in evidence." Mr. Davis says, "No, sir, I am not." And the court says, "No, he is not. I don't think he is. If he does, then the objection will be sustained." Mr. Davis says, "Yes, sir." And the court says, "Stay within the record." Mr. Davis continues. And what did Darren Routier say to you good people? He said, that is my sock, and it came out of that utility room. It's my sock. Just like Charlie Lynch had told you after his microscopic examinations. Now, let's talk about the sock for just a second here before I go on. I'm not telling you that this defendant went down there in some clever effort to plant the sock. I'm not saying that. Mr. Shook is not saying that either. What we are saying to you is that this woman knew very well that this sock right here came out of her house. She knew good and well that she was going to get it out of that house and try to disassociate it from that house. You see, she never counted on that knife being found in that butcher block with that fiberglass. But she knew that that sock right there had blood on it. And how is she going to ever explain that? Get it out of the house. It wouldn't take her very long at all. And that is exactly what she did in this case. And the telltale thing is the blood that is on there. Whose blood is on the sock? Is it the blood that we would expect to see from some intruder who came over there and stuffed it down her mouth, attacked her, slashed her throat? Is it her blood? No, it's not. It's only the two boys and about a nickel-sized stain. Not her blood. The next man to attack was Tom Bevel. Well, let me back up to Charlie Lynch one more time here. We know, as they criticized Charlie Lynch, we know that back in August of last year that there was an expert by the name of Bart Epstein, a trace evidence analyst there at Swifts on behalf of the defendant. And we know that back there in August that Charlie Lynch said, here, I will show you everything that I am doing out here. He let him look at these slides, let him examine the evidence. Basically, he looked over Charlie Lynch's shoulder and graded his work out there at Swifts. And don't you know that if Bart Epstein had any disagreement whatsoever with the findings of Charlie Lynch, that you would have seen him up here on this witness stand? Because we know that this defense team here, when they need a witness like Richard Coons, hey, you can place a phone call at 9 p.m. and they will get him here the next morning. So where is Bart Epstein? You know why he is not here, because there is nothing wrong with Charlie Lynch's work in this case. As we look to Tom Bevel, as they criticized Tom Bevel on his opinions, that videotape, and you have got the t-shirts back here. As you look at that videotape with that motion demonstrated by Tom Bevel, and you will find that they weren't long on the back. Those bloodstains, they are the same size and consistent with the size of Devin Routier's blood that was deposited on the back of this defendant's shirt. That is what the videotape and the t-shirt will show you. Mr. Mosty demonstrated about picking up this vacuum cleaner. Listen, it's not that hard, and you can try it yourself. You don't have to hold it down here by the neck. If you hold it right up here and you roll it around as this defendant did that day, what do you get? You look at my hand and you will see you get the blood smear right on the side of this handle, exactly like she did that day. Here is the bottom line on Tom Bevel. Out there at Swifts, there is another expert, Terry Labor. He is the DNA blood spatter expert who went out there on behalf of the defendant also, along with Bart Epstein. And if they want to quarrel with Tom Bevel and tell you that he is wrong and that he is a witch doctor of some sort, where is Terry Labor then? Where is their blood spatter expert? Don't you know that if he had any criticism of the opinions rendered by Tom Bevel, that just like Bart Epstein, you would see them right up here and he would be detailing for you what those criticisms are. But he is not here either, is he? And for a very good reason. There is one other thing that we need to ask also. Where are the samples from the t-shirt taken by Terry Labor? Where are they? You remember those first dibs samples that Terry Labor took from the defendant's t-shirt back in August? Before Tom Bevel even had a chance to look at the t-shirt, Terry Labor, the defendant's expert, went to Dallas and was given an opportunity to take several samples from that t-shirt. Did you see those samples in this courtroom at any point in this trial? No, you didn't. Don't you wonder why? You really don't have to wonder long about that question. It's obvious to you. Why those best samples taken by the defense, why you never saw them, and why you never heard a test result or a DNA result on any of the samples. It speaks volumes to you sometimes, what you don't see and hear. And it speaks volumes in this case with regards to that t-shirt. Well, after you have beat up on the police and you beat up on the nurses, the forensic experts, next to last, you try to change your story. You see, you can still win this case if you are the defendant, if you can change the facts, and if you can go back and say, by the way, I remember my wife. She was right over there with me doing that CPR on Devin, even though I have never said it to anybody before. Yeah, she was over there at that sink. Now that I know that the sink has been cleaned up and there is traces of blood, by golly, I just happen to remember that she was over by that sink. And then when her blood is found on the vacuum cleaner, the DNA results come back. You say, well, by golly, I guess that just slipped my mind too. My wife was over there using that as a cane or a crutch. Then, if you are the defendant, you do the very same thing. All of a sudden, through this traumatic amnesia, you remember the Devon CPR, you remember the sink, you remember the vacuum cleaner, you remember the bruises on your arm, and then even you remember that you didn't wear panties that night or they were taken from you. So if you change enough facts, folks, nobody is ever guilty if you can do that. And when that one failed, as it did in this case, what is the last thing that you do? What you do is you say traumatic amnesia. I think it would be fair to term that the I can't remember or I won't remember defense. It's just like Mr. Shook talked about with some of those doctors. And if you say, I don't remember, how do you get at that? If I told you people, I don't remember something, is there any number of questions that you could ask to make me remember something like that? It's convenient, isn't it? It's very convenient in this case. And in order to try to prove that defense, they bring Dr. Lisa Clayton, and I have got no quarrel with her, but it really seems strange to me that when Mr. Mulder said that she had freedom to do whatever she wanted on this case, it just strikes me as just a little bit funny, the very limited number of things that she chose to do. Who does she talk to? Well, she talks to the defendant quite a bit for 12 hours. She is a real objective source of information, don't you? She talks to her husband. You have all had a chance to see Darren Routier. Need I say more? Okay. The family, her in-laws, kind of a one-sided picture that we're getting here. Put that is the picture that Lisa Clayton chose to see. No paramedics, no police officers, no nurses, no doctors, no one outside of the immediate family of Darlie Routier. And then she comes to this startling conclusion that she thinks that Darlie Routier is telling her the truth. It's a bit mind-boggling that she would do that. But then again, this is the doctor, the psychiatrist who would have you and I believe that there is nothing inappropriate 8 days after your children have been slaughtered to go out to their graves and shoot some silly string and laugh and carry on. You see, when we look at that tape, according to Dr. Clayton, and our stomach turns a little bit because we still have consciences and those things bother us. It's our fault. Don't you understand? Because we don't know what is appropriate and not appropriate. That is Dr. Clayton's take on this case. And then I guess maybe she doesn't do a good enough job. And so Richard Coons is called in. I guess coincidences happen in life. But this one seems a bit far-fetched that he calls at 9 o'clock on Wednesday, after about 4 hours after the defendant testifies in this case. I can imagine that call going out. Is there a doctor in the house? The defendant has mortally wounded her case, and we need a doctor down here now. And so Richard Coons comes to Kerrville, and I have got no quarrel with him, believe me. He is an eminently qualified psychiatrist and a fine gentleman, and I think he told you the truth as he sat on that stand. There is only one problem with Dr. Coons, though. They didn't give him any facts, did they? Oh, they gave him a lot of hypothetical questions from Mr. Douglas here, a lot of assumptions that were all favorable to the defendant, and then he answers the questions. But you see what happens when you change those a little bit, as Mr. Shook did, and you start talking about some of the facts, the actual true facts in the case, his opinion started to change, didn't it? And I think it's very clear why they chose as they did, because that is their witness. It's very evident why they chose not to give him any facts at all to work with, because they knew, as you do, that if you give that man, because he is honest, if you give him the facts, he may give you an answer that you don't like. Mr. Mosty then says, Your Honor, I'm going to object to that. He was called as a rebuttal witness. He could only rebut. He can only be called to rebut what the state has put on. That is the only purpose that he can be called for. And the court says, Thank you. The jury is instructed to remember the testimony as they heard it and be guided by the charge of the court. You have 15 minutes left. Mr. Davis continues. Thank you, Judge. Well, I told you what a guilty woman does. And very quickly, as we walk through here, let's talk about what an innocent woman does and doesn't do. You ask yourselves these questions as I go through here using the common sense test. And really, that is the best thing to hang on to. You have heard a lot. Hang on to your common sense. But as I go through here very quickly, does an innocent woman, a light sleeping innocent woman, does she sleep through the of a child that is 5 feet away from her? No, she doesn't. Does an innocent woman sleep through the of her child as he is 1 foot away from her? No, she doesn't. What do innocent women do? They come to the defense of their children, is what they do. And does an innocent woman then sleep through her own attack? Puncture wound to the arm, slashes to the neck, to the left shoulder? Does an innocent woman sleep through her own attack? You know, I don't even have to answer that one. Your common sense gives you the answer. Absolutely not. But in all 3 cases, this is what this woman claims to have done. And she did it because she is not an innocent woman. When she wakes up, does an innocent woman look up and see an intruder and not immediately yell upstairs for her husband? No. And does an innocent woman wake up, see her children here bleeding, and then leave them and chase into a darkened kitchen and utility room after an armed intruder? No. But that is not what this woman did, is it? What she did is not consistent with what an innocent woman does. And does an innocent woman, while her children are literally bleeding at her feet, look around the room and make sure that none of her jewelry is gone? Heaven help us if that is what innocent women and mothers do, and that is what parents do. No, they don't do it, but that is exactly what she did that morning. Looking around to make sure the goodies aren't gone from that kitchen bar. And do innocent women, innocent mothers, again, as their children are bleeding, do they worry about leaving fingerprints on a knife handle? Of course not. But that is exactly what this woman did, because she is not an innocent woman. And do innocent women have to give 8 accounts of what happened? All different accounts? I'm not going to run through all of them, but basically, to Waddell, the fight was at the kitchen bar. To Walling, the fight was at the couch. To Jody Cotner, Damon shook her and woke her up and followed her in the kitchen. To Diane Holland, there is an intruder over her immediately and she felt pressure and there is a fight at the couch. To Paige Campbell, the intruder is over her and he tried to stab her. She grabbed at the knife. She never saw his face. To Denise Falk, Damon was crying to wake her, a struggle at the neck, wrestling on the couch. Barbara Dovell, Damon woke her by saying, "Mommy, mommy," and pressure on the legs. And in her voluntary statement, she just says a man is walking away from her. Listen, folks, if you are telling the truth, it doesn't take 8 shots at it to get it, because the truth never changes. Once is enough. But that is not what this woman did, because this woman right here is not an innocent woman. This woman here is guilty of capital. And does an innocent woman, can you imagine in your wildest nightmares, an innocent mother sitting across the table from Bill Parker and having Bill Parker accuse her of her own flesh and blood several times and remaining polite for a 3-hour period, or never denying the fact that she her children? And can you imagine an innocent mother sitting across the table from Bill Parker and he says, "I know you your children," and an innocent mother just saying, and shrugs his shoulders? No, they don't. This is not what she did. You see, because this woman right here is not an innocent woman, guilty of capital murder, Darlie Routier. You know you have got a very simple choice here. You have got a choice of either this woman sitting over here, Darlie Lynn Routier, her two children, or some mysterious lucky intruder did it. And he indeed has to be a lucky intruder, doesn't he? Happened to pick the night that the window is open, happens to pick the night where a sock is conveniently in a utility room. We haven't even mentioned how he got in. I guess the guy just had to slip down the chimney to get the knife, then go out and then cut the screen and then come through the utility room. But when he got in there, lucky fellow, the knife is in the butcher block. Lucky fellow that he two children without the mother waking. Lucky fellow that when he cuts this woman over here, she can't describe him. Lucky fellow that he drops a knife on the floor as he leaves, arming his victim, and she doesn't pick it up and wound him. Lucky fellow that he leaves no trace in the garage. Lucky fellow that he leaves no trace in the backyard as he leaves. Those are your choices here. And as you go through here, and as you look at the hard scientific physical evidence, as Mr. Mosty asked you to, and I will also, when you look at that screen being cut by that knife inside the house as it was, that is really as far as you have to go with the hard scientific stuff. Because if that fact is true, that that screen on that window was cut with the knife inside of that kitchen of the defendant, that answers all of the questions that you have in this case right here that you need to answer. Now, you know from the scientific evidence that was the case. And as you look at Devin's blood on the back of that t-shirt, you know how that was deposited. And as you look at the boy's blood on the front of the t-shirt, you know how that was transported to her t-shirt. As you look at the utility room floor, you know that the floor is totally inconsistent with the story that she gave. There is no cast off pattern, and you know from the scientific evidence that that was the case. The blood on the vacuum, the roll marks that she made in the kitchen as she staged that scene, and the sink being cleaned with the blood hidden behind the closed drawers and doors to that sink. The physical evidence is there. It points not at many people, not at some people, but it points very clearly to this woman right here, Darlie Lynn Routier, and only Darlie Lynn Routier. You know she did it. And they keep saying that I didn't show you why they did it. And I think I did. We have got a pretty good snapshot look at what this woman's life was like back then. It's so desperate that on May 3rd of 1996, in this beautifully normal American home with no problems in it, this woman is contemplating. You know it wasn't good in there. You know the pressures were building up with the children. You know she was unhappy that she hadn't had a girl. She was unhappy with her weight and with her appearance. She is unhappy that she is not getting the attention from her husband that she wants to get out there. And she is unhappy about that financial situation. Those numbers don't lie there. You can see that if you average it out. These people are going to take in $90,000 less than they took in 1995. That is not bad money, but when you are used to 260, 170 is not going to cut it. You know the pressure was there. You know why she did it. You have a very good idea. Only God and she knows exactly why she did it. But we have a pretty darn good idea, don't we, of the kind of pressure that was building up that night on June 6th of 1996. You know, these two children here, well, they lived in Rowlett, and I never had the pleasure of meeting them. But you know, once upon a time, they were ours too. They weren't just Darlie Routier's children. They were ours. You see, they were our neighborhood kids too. The kids we saw running up and down the streets on their bicycles. They were our classmates. They were our students. These children right here. In a real sense, they were our future. You know, and as these two precious children laid on that carpet, looking up with those opened eyes, literally drowning in their own blood as they laid on that carpet, as Mr. Shook said to you, the very last thing that each of these children saw was their killer. Can you imagine what it must have been like for those two children that morning as they saw this woman right here? And at this point, you hear actually from Darlie, where she says, liar, liar. Mr. Davis says, she says, liar now. And Darlie says, you are a liar. Mr. Davis says, see, but, and she says, I did not kill my kids. Mr. Davis continues, but they looked up there and they saw this woman right here in a rage coming down on them with that knife. And that is the very last thing that they saw. They saw their killer. And after these 4 weeks, you have seen her too. Her name is Darlie Lynn Routier. She sits here before you. And I'll ask you now to go back to that commitment that you all gave to us. You said that if we proved our case beyond a reasonable doubt, as we have in this case, that not only could you, but you would find this woman guilty of capital. And that is exactly what I am going to ask you to do at this time, because the facts in this case show her to be guilty of capital. The court says, thank you, Mr. Davis. Ladies and gentlemen of the jury, if you will retire to the jury room now, please. If you will select one of your members as presiding juror, and when you have reached a verdict, please contact the bailiff who has you in charge at the time. And at this point, the jury is excused from the courtroom and they begin their deliberations at 1:40 in the afternoon. While the jury is out, there are still proceedings going on inside the courtroom with the defendant, with Darlie and the attorneys, but obviously no jury. And the court says this. All right, ladies and gentlemen, here is how this is going to work. We can't get all of these exhibits in the jury room. So we're going to let the jury deliberate in here. That means that all of you will be downstairs. We will be in the offices up here should anything be needed. If a verdict is reached, believe me, you will know. We will not do anything without calling everybody up. We will have to ask you to step downstairs, please, and remain there until given further notice. So at this point, the audience is then excused from the courtroom, and then the proceedings are resumed on the record. Obviously, the attorneys and Darlie are still there, but outside the presence of the jury, and it continues as such. The court says, all right, let the record reflect that these proceedings are being held outside the presence of the jury and all parties in the trial are present. The charge having been read to the jury, the following 3 alternate jurors are now discharged. And then he reads off the names. We want to thank you very much for your service, and we appreciate all of your time and for any inconvenience. We certainly apologize for it, and we appreciate everything that you have done. If you will leave your juror badge here now, we have an officer that is going to escort you down the back stairs of the courthouse. And please, do not discuss this case with anyone until it's all the way over. When it is all the way over, if a verdict comes in, for example, of not guilty, it will be over. If a verdict comes in, for example, of guilty, then we have to have another hearing. So please don't discuss it until it is all the way over. After that, you may discuss or not discuss it as you see fit. If you want to talk about it, you can. If you don't want to talk about it, then you don't have to. That is anybody. The press, the lawyers, anybody. It's just your call and your judgment. Please don't discuss anything about it until it's over. Thank you very much again for all of your hard work and your services. So the alternate jurors are excused from the courtroom and the proceedings were recessed pending the deliberation of the jury. And at 6:00 p.m., it goes back on record and the court says, all right, let the record reflect that these proceedings are being held outside of the presence of the jury and all participants in the trial are present. These proceedings are being held in chambers. We have present for the defense, Mr. Mulder, Mr. Mosty, and Mr. Harrell, and for the state is Miss Wallace. I have received the following note. Quote, some of us remember hearing Darin say that he did not lock the door from the utility room to the garage before he went to bed, 6/5/96. The rest of us remember that Darin said he locked this door. Which is right? And then it's signed by the presiding juror. Now, Miss Halsey has looked that up and you have seen the reply. Does either side have any objection to the answer to the note? Miss Wallace says no objection from the state. Mr. Mulder says no objection, Your Honor. And the court says, all right. Just for the record, both sides agreed to giving this note back to the jury, just like it is. Ms. Wallace says the state has no objection. Mr. Mulder says the defense has no objection. The court says, all right. And just for record purposes, Mrs. Darlie Lynn Routier is not here for this hearing. Do you wish to waive her presence, Mr. Mulder? Mr. Mulder says, yes, sir. And the court says, Mr. Mosty? Mr. Mosty says, yes, sir. And the court says, all right, you may send the note back to the jury. These conversations occurred and the jury had gone back on January 31st of 1997. And the following day, the jury was back with a verdict. Everybody comes back into the courtroom. The court says, all right, be seated, please. Let the record reflect that all parties in the trial are present and the jury is seated. Mr. Walker, has the jury reached a verdict? And Mr. Walker is the foreman of the jury. And he says, yes, we have, Your Honor. And the court says, all right. We, the jury, find the defendant, Darlie Lynn Routier, guilty of the offense of capital murder as charged in the indictment. Ma'am, will you please be silent, please? That is signed by Frank S. Walker, presiding juror. If that is your verdict, please so signify by raising your right hand. And at this point, each juror on the jury raised their hand that the verdict just read by the court was their verdict, after which time the proceedings were resumed as follows. Let the record reflect that all hands were raised. May I see both sides briefly, please? So at this time, a short discussion is held off of the record, and then the proceedings are resumed. And the court says, all right, ladies and gentlemen of the jury, as your name is called, if your verdict is guilty, please raise your right hand. And then they go through each of the jurors, and each of the jurors raise their hands. And the court continues. All 12 jurors have indicated that the verdict is guilty. It will be necessary now for you to set punishment in this case. We will commence that at 10 o'clock on Monday morning. Now, it's going to be set for 10 o'clock because Judge Prohl has one brief matter that they must take up in this court at 9 o'clock. So if you will step back to the jury room, please, for just a minute. Now, the same instructions as always. The case is not over yet, so do not discuss this case with anybody. When the case is over, you may talk to anybody or not, as you see fit. Do no investigation on your own because you will decide this case on the testimony you hear and the evidence you will receive in this courtroom. If someone tries to talk to you about this case, please tell the bailiff who happens to be with you at the time, and please ignore any publicity you may see in the newspapers or the radio or the TV. In fact, it's just a good idea not to read any newspapers or look at TV or listen to the radio pending the outcome of your jury service in this case. And wear your juror badges at all times in the courthouse area. If you will step back to the jury room, please. Thank you. So at this point, the jury was excused from the courtroom and then proceedings were held in the presence of the defendant, of Darlie, and the attorneys. And the court says, all right. Both sides will be prepared to go forward Monday morning at 10 o'clock. Mr. Greg Davis says, yes, sir, we will. The court says, thank you. If I could have one attorney from each side to remain briefly, please. Ladies and gentlemen, that concludes these proceedings. The courtroom will now be cleared. Thank you. And at this point, the audience clears the courtroom, and the court says, I intend to send the jury back home for the remainder of the weekend, and then have them come back on Monday for the remainder of the trial. Does either side have an objection to that? And Mr. Davis says the state has no objection. And Mr. Mulder says, no, we have no objection, Your Honor. And the court says, all right. So as you've heard, the jury is then sent home for the weekend, and they will be back on Monday to do the punishment phase. And we will hear further testimony. Each piece of testimony in the upcoming portion of the punishment phase is actually fairly short, and there's going to be quite a few people who testify during this punishment phase. So that will be started in the next episode. So let's do our usual recap and talk about just a few things. After Mr. Davis offers his thanks to the jury, He starts to talk about the different tactics that Darlie's team has used, one of them being the Susan Smith defense. And he calls this the phantom intruder. And for those who aren't aware, Susan Smith was a woman from South Carolina who in 1994, so literally just a couple of years prior to this case, falsely claimed that her two sons had been kidnapped during a carjacking. It was later revealed that Susan Smith had actually driven her car into a lake and drowned her children. So, if you were curious as to what he meant when he said the Susan Smith defense, this is what he was talking about. The next thing that he does is he covers all of the different arguments that the defense team has made as to who this intruder might be. First, Glenn Mize, then Gary Austin, who lived down the block, and then the woman who said that her house was the scene of an attempted burglary on Miami Drive, and those suspects there. Then we hear about someone new, someone we have never heard about before, a man named Wilford Davis. Now, this was after the description of the man was given by Darlie of someone who had a dark t-shirt on and a dark cap. We then learn that, there was then this phone call the same day of the 6th. You recall that from the previous episode that had come in, and evidently they found this guy, I guess, this guy named Wilford Davis. Anyhow, they said that the prosecution then goes on to say that they learn that this man's fingerprints were tested against the fingerprints in the window. And I was a little confused about this one because then Mr. Mosty of the defense team interrupted and said this was outside the record. And then another defense attorney spoke up and said that if this were true, the defense knew nothing about it. And Mr. Davis, the prosecutor, said that it's not exculpatory evidence, which essentially means that exculpatory evidence is any proof that can help show someone who's accused of a crime, so in other words, Darlie, to show that she is innocent or less guilty. So he's saying that this information about these fingerprints and this gentleman was not considered exculpatory evidence. This conversation continues for a bit, but I promise you, Mr. Davis knows exactly what he's doing. He's already boasted that he has 19 years of doing this, right? So, of course, he did this on purpose. The judge simply tells the jury to only be guided by what's in the record, but you know that this is going to be in the back of their minds, right? Davis then continues and said that the next person to be accused was some, quote, drug-crazed maniac. He then said that when all of this doesn't work, you then just blame the police. And he twists the truth here a bit when he starts to talk about Darlie being in the crosshairs of the Rowlett Police Department from the very start. And actually, this argument wasn't made about her being in the crosshairs until after James Cron appeared and did his walkthrough. But Davis, in his closing, is making it sound as if this targeting of Darlie was done even before Cron showed up, or that Darlie at least believed this before Cron even showed up on the scene. Now, after talking about Darlie's bruises, he then talks about the fibers found on the bread knife, and again, begins to talk about something that is not in evidence and is objected to, the subject of the fibers on the sock found in the alley, and that they were consistent with the fibers of Darin's shoes. Now, I seem to remember that they did touch on this. I can't quite remember, just pulling it from memory, but I do remember something about the fibers on the sock and Darin's shoe. Now, Mr. Shook then continues his closing and tends to twist a lot of the facts in the case. For instance, when he said that Darlie woke up and saw her children, but instead she chased the attacker instead of tending to her children. And this is not actually what happened. She woke up, she saw the attacker, and then when returning to the room, she saw the children. This continues with the statement about her jewelry on the counter. He conveniently left out the fact that an officer had first mentioned something about, hey, are there any items gone? He does this quite a bit with things that the jury knows about, but it's almost as if he's trying to deliberately confuse them. After Mr. Davis is done talking and the jury is sent back to the jury room to deliberate, it's 1:40 in the afternoon. At 6 o'clock, just over 4.5 hours later, the jury has a question about Darin locking the door to the utility room. The following day, on February 1st, 1997, the jury has reached a verdict: guilty. Now, the jury's job is not yet done. On Monday, February 3rd, we move into the punishment phase. And in the next episode, we'll begin to hear from various people who speak to the character of Darlie. So until then, thank you so much for listening. I appreciate all of you. Don't forget to subscribe and keep up to date on the latest episodes. As soon as this trial is finished, Beach House 34 will be back to doing weekly true crime and paranormal episodes. We will talk really soon. Bye for now.